all. Hello and welcome to the panel discussion AI, Justice and Public Power. I want to thank all our speakers and all participants who are interested in these issues. The idea behind the discussion was to have a quite broad discussion about
Recording
AI,
in progress.
AI impact on people and societies, to see some benefits and dangers AI has. And of course, we want to start with the issues of responsibility. I also want to thank Yaroslava Mudrago National Law University and European Union for supporting our project, because this discussion is also part of project Jean Monnet Center of Excellence, European Fundamental Values in Digital Era. That's quite a big one, and we will invite you to other activity, of course. So let me share the program just to have some organizational issues. So we will start today with two speeches around AI responsibility, or maybe responsibility of someone who involved in AI issues. And I hope the discussion will be really great. So the time frame is to have up to 30 minutes for presentation itself and 15 minutes for discussion, but we can redistribute it in time frame, and we will end 15 minutes before 11 in Central European time. To finish this organizational part, I just want to say that I will moderate this event with my dear colleague Natalia Filatova-Belarus, and I'm a project leader in the European Jean Monnet Center of Excellence. And Natalia is one of the best researchers in our team, and she is also the head of the international hub. That's an interdisciplinary research hub on European fundamental values and digitalization within this project. So, as we have now all who want to attend in this morning slot, I'm happy to start with the presentation of Pьотра Махніковські. Pьотра Machnikovsky is the professor of civil law and head of the Department of Civil Law and Private International Law at the University of Wrocław. He is also a member of the European Group on Tort Law, and he has served as an expert for the European Commission in its work on AI liability. And his presentation is about AI and civil liability, EU legislative proposals. Dear Pьотра, the floor is yours.
Thank you very much. And first of all, I'd like to thank you for the invitation. It's a great honor for me to be able to speak at this forum. As we chatted a little bit before the opening of the program, we all hope that we will be able to meet in person next year. And I would also add that I also hope that we'll be able to talk next year, or maybe in a very near future, about the EU law with our Ukrainian colleagues as citizens of the EU member state. That's my sincere hope, and I believe it will happen sooner rather than later. But for the moment, my topic is AI and civil liability in the EU context. And first, I'd like to explain that what I will be discussing is only a small part of a broader program that the European Commission started in order to adapt the European law to the requirements of the digital age. The most important part of this program is the regulations which determine the acceptability of the use of AI in various fields of activity. So what we usually call regulatory framework, in which cases and under which conditions you can use artificial intelligence in your activity. Of course, the main assumption is that it is allowed, with some reservations for some particularly high-risk uses of artificial intelligence. The less fundamental but still important part of this program is defining the consequences of harming someone by an activity in which AI has been used. So the part which relates to a duty to compensate for loss, to compensate for personal injury, to compensate for damage to property, for other losses, potentially also for so-called pure economic loss, to compensate for economic loss, and to compensate also for non-economic loss, that is pain and suffering or impairment of the quality of life. This is the issue which is also very prominently on the table. And I will devote my speech to this part of the program, that is how to make sure that proliferation of the AI and all the benefits that the AI, in general, digital technologies bring, will not come at a cost for individuals who will have to suffer the burden of damage they may suffer because of the use of digital technology. But having said that, I would like to also stress that we do not assume that digital technologies are inherently dangerous. That's not our starting point. To the contrary, we assume that digital technologies and artificial intelligence are inherently beneficial. As we all know, advanced computer programs are better than humans in their usually quite narrow respective fields of activity. And we hope for, we expect a lot of progress, a lot of good things happening because of introducing AI in certain areas such as medicine and design and so on. But still, accidents happen. So even if the AI is in general a positive force in the progress of humanity, we must assume that first, it can be used in a harmful way. So it can be used with a view, or at least contemplating the possibility of harming someone. And also, as I said, simple accidents can happen. So mistakes may happen, defects in the code may happen, which may result in somebody's harm. And these issues, that is, the duty of one individual to compensate for the harm suffered by another individual, are dealt with by tort law. And in the European Union, this issue falls overwhelmingly within the competence of member states. So the tort law is in, I would say, 99% a member state issue. The competence of the European Union is quite limited, and the harmonized EU tort law is only certain pieces or certain bits of the whole picture. Most notably, the harmonized rules apply to the cases of so-called product liability. That's liability for damage, which is borne by a producer because the damage was caused by a product he has manufactured and placed on the market. So product liability, producer's liability is harmonized on the EU level, and this single set of rules applies in all member states. And I will return to this issue of product liability later, because this will be the main focus on my speech. So the Union is taking steps to promote the use of artificial intelligence, and at the same time it strives to ensure that its citizens are protected from harm. And to this aim, certain legislative initiatives have been taken, and I will discuss them, or we will actually, together with Professor Pazos, we will discuss them today in the morning. And I will start with presenting 4 possible solutions. So if we imagine a situation where somebody is using, or certain digital technology, certain AI system is in place, is in operation, and somebody has suffered damage as a result of this digital technology being in operation, there are basically 4 solutions possible. First one, no one is responsible for the damage. So the state, we can call it a 0 point. The damage lies where it falls. The one who suffered will have to bear the consequences. The accidents happen, and that's all. But in many cases, either considerations of justice or simple common sense require that the damage should be repaired. The damage is repaired. So this first solution, that is, accidents happen, and if you suffer damage, that's basically your bad luck, is not one we would like to adopt blindly. There are many instances where we believe that somebody else is or should be responsible for someone's loss. The second theoretically possible solution is that the artificial intelligence is supposed to repair the damage itself. It's a quite popular idea in, well, I would say, general discussions on artificial intelligence, something which is called AI personality. That is a rule which would, a set of rules which would result in giving the artificial intelligence a personality modeled after the personality of a human being, so making the artificial intelligence liable for damages it has caused, or for harm it has caused as a result of its operation. Of course, there's a lot of philosophical problems with that, because usually the personality, legal personality, or legal entity was something which was either reserved to human beings as a living and, in our human view, unique entities, or it was granted to some organizations for pretty practical reasons, because it's easier to treat a group of people as a single entity than to treat them as a group of people and analyzing their individual separate activities and trying to find out how to attach legal consequences to those individual activities. So there were either philosophical or practical reasons, and both of them are quite vague in case of AI at the moment. But I would, as I said, I will not go into details of this philosophical discussion, because there's one sufficiently important practical reason for not granting AI liability for the purpose of not granting it personality for the purpose of civil liability. It's simply because civil liability is economic liability, is a duty to compensate, a duty to pay damages. And if someone is to be burdened with the duty to pay damages, that someone must have assets. And to have assets, such an entity must first have ability to conclude, to enter into contracts, the personality in the sense of being a participant of the market, and then it must be able to generate income and to accumulate assets, so that the civil liability have any practical meaning in case of that entity. This is the reason for which we should not speak about liability of the AI at the moment, because it will be an empty shell. Actually, there's an argument which makes a lot of sense to me, which says that granting a personality to the AI for the purpose of civil liability is actually granting an immunity to someone who is using the AI if its activity, in his or her activity, because if the AI is liable and has no assets, and I'm not liable because it's not my deed, it's an AI deed, then the damage will not be compensated. So this is an option which should not be taken seriously at the moment. But there are two remaining options which in turn should be taken quite seriously. The first one is that the harm should be repaired by the one who used the digital technology for his own or her own purposes. So something which we call users or operators liability. So if I use the technology for my own purposes and this causes harm to somebody else, there should be my liability. The fourth option is the liability of someone who has produced the digital technology in question. So liability, producer's liability, the one who manufactured, the one who developed, the one who sold for the first time, put on the market. the technology in question is liable for damage that the technology has caused. And these two options are currently being considered by the European Commission. And the Commission has prepared two legislative proposals to address those two liability options. The first one, the so-called AI Liability Directive proposal, it has a broad scope, but it, among other things, it addresses the case of liability of an operator, an user, for causing damage to somebody else, but for causing damage through the user's own fault. So this is so-called fault-based liability. It is liability which someone bears because not only his action caused damage to somebody else, but also his action was negligent. So there was a certain standard of behavior that applied to that person, and this person did not live up to the standard in the circumstances, and that's why, in this case, the AI operator is liable. This is liability which is governed by member states' law currently, and the proposal of this so-called AI Liability Directive aims at making it easier for the injured party to claim compensation by introducing certain procedural rules. So it does not go into the core of a substantive law on negligence-based or fault-based liability. It addresses obstacles to getting compensation from the procedural point of view. But I will stop myself at this moment because Professor Rikardо Pazos will talk about this draft in a few minutes. And I will go to the second proposal, that is the draft new directive on liability for defective products. So I would like to devote the rest of my speech to the second proposal. But I have to start with a short description of the current state of play. So what do we have now in the European Union in the field of product liability law? We have member states' laws which implement the EU directive of 1985. So it's quite an old piece of legislation. Actually, it's older than the date would suggest because the directive was adopted in 1985. But the first proposal was tabled by the Commission in 1975 or 6. I don't remember exactly, but it's about 10 years earlier. And the first draft from 1975 or 6 was strongly influenced by the legal thinking of 1950s and 60s in Europe and in the United States. So in short, it's a piece of legislation which is deeply rooted in the mid-20th century. It's based on simple premise that there can be and there should be one liability regime for all types of products, which may be quite surprising because we know that there are very different kinds of products. And to mention just one, pharmaceuticals are completely different products, and I would say hammers, nails, shovels, and other things. But the Commission and then the European Council, when they adopted the Council of the European Communities, when they adopted the 1985 directive, they believed that sufficiently flexible set of rules will deal efficiently with all problems with all products can generate. And the sufficiently flexible set of rules was based on one basic rule. So it boiled down to a simple proposition. The proposition is that whoever, in the course of his or her economic activity, manufactures and markets a product which is a movable item, so a tangible thing, and the product which at the time when it was placed on the market is defective in the sense of unsafe, risky, then this person should be liable for personal injury and damage to consumer property, which was caused by the defectiveness of the product. So main points of this idea is that we have a producer who is a business, a trader. The producer produces a movable item, a tangible physical product. At a certain moment, the producer puts this product on the market, puts it into circulation, sells it for the first time in most cases. At this moment, when the product is put into circulation, the product is defective. And this defect later on causes damage to somebody else. If these conditions are fulfilled, then the producer has a duty to compensate for the damage, but the duty is limited only to personal injury, that is illness and things like that, and to damage to property, but only this kind of property, only that property which is used for personal purpose. So it's so-called consumer property, not business property, not used in professional activity to generate income, but only to satisfy one's personal needs. And this fundamental rule is subject to certain modification in the current law, but this is, I would say, this is the cornerstone of the whole regime. And there are certain modifications. First set of modifications concerns the burden of proof. But as I said, the producer is liable if he puts on the market defective product, and the product causes, the defect causes harm. But the burden of proof is distributed a little bit differently in order to facilitate the victim to get the compensation. That is, the injured party, the victim, must prove first the manufacture of the product, so that my defendant is a producer of this product. Then the victim, the claimant, must prove the defectiveness of the product. So the product was defective. He must prove his own damage and the causal link between the defect and the damage. So these four things. This is the producer. This is his product he put on the market. This is the defect in the product. If this is my damage, which is a result of the defect. And if the claimant is successful with proving these elements, then the defendant can discharge his liability by proving that either he did not place the product on the market, or he did not do it in the course of his economic activity. So to put it in a little bit simplified terms, the product left the producer without the producer's will, so without producer's knowledge, and against the producer's will. Then the producer can relieve himself from liability by proving that the product was not defective at the time it was placed on the market. So the law assumes that if the product is defective at a certain point of time when it causes damage, it was defective from the very beginning, from the moment it left the producer's facility. And if producer has evidence to prove that the defect came into being later, so the product was okay at the moment when it was first time sold, but then because of transport, because of storage, because of bad dealing with the product, it became defective, then the producer must prove that, because otherwise we assume that it was defective from the beginning and the producer is liable. So this is the first set of modifications. The second set of modifications consists in broadening the personal scope of liability, because the basic idea, and historically, the basic idea was that the producer is the one who, well, to put it simple, who caused the damage, because he has manufactured a defective product and put it into circulation. But the legislators realized that there are some other people who either participate in this causal chain or should be responsible in place of producer, or more likely alongside the producer, for some other reasons. So the current law makes following people liable also for damage caused by a product. First, the manufacturer of the defective material or component. If somebody has produced a defective material or raw material or defective component, and this defective material or component caused the defect of the final product, and the defect of the final product caused the damage of the victim, then there are all arguments in favor of making this producer of the component liable, because the same reasoning applies here. Actually, the producer of a component is the one who produced something defective which caused damage. So the same rule applies. But also the current law makes liable the person which is, so to speak, claiming to be the producer. So the one who places its own trademark or other mark on the product in order to create the impression that this person is a producer, not the actual manufacturer. And we know this phenomenon mostly from chain supermarkets, which sell a lot of products under their own brand, so-called own brand goods, which is manufactured, of course, by somebody else, but it bears a logo of the supermarket chain, and it creates impression that it's a product manufactured by the chain operator and not by the actual producer, who usually remains anonymous. But also another quite often situation, gastronomy franchises, food franchises. When we enter a burger restaurant belonging to a chain of burger restaurants, we buy something which was produced on the spot by somebody who is running this business. But there's a logo of a chain on it, and we expect the quality we are accustomed to when we enter the premises of this chain, and we have no expectations, actually no idea about who actually produces the burger in question. So this is another person which is liable as a producer, the one who the so-called own brander, or the one who puts his own brand on the product. Then another person who is liable under the current regime is the importer of the product into the European Union. So a business which imports the product from abroad, from Asia, from the United States, from anywhere, to the European Union. And in this case, the reasoning is a little bit different. So justification for claiming damages from the importer is not that he produced or he pretended to produce the product. He did not. The justification is that, first, this is the person which contributed to the risk by bringing the product from outside the EU, also from outside the protective regime of the EU product safety law, bringing it into the member state. And another justification is that usually it's the only person which can more or less rationally be sued by a victim, because it's practically impossible to sue a producer deep in Asia. Quite often we even don't know who the producer is, let alone filing a suit and then executing the final award, or executing the judgment. So for the protection of potential victims, we allow them to sue the importer. That's the main reason behind this rule. And for similar reasons, the current law, the 1985 directive, allows also for claiming damages from the seller of the product, so the supplier, the part of the supply chain, my last final seller or his seller, and so on. But they are liable only in case where the producer cannot be identified. So they are sort of liable in place of an absent producer. What is the most important feature of this liability regime is that it is independent of the producer's fault. So whether the producer acted negligently or not when he manufactured and put on the market a defective product doesn't matter. What matters is that the defective product was placed on the market. This is, I think, this was the revolution in the development of tort law, when the non-fault liability regime for products was introduced, because before that, the victim had to prove not only that there's a defective product in the circulation, but also that it's a fault of the manufacturer. So the manufacturer acted negligently either in designing the product, or in manufacturing it, or in checking the quality, or in the quality control. That there must have been some instance of not living up to the standard on the part of the manufacturer. And that was difficult, of course, because an ordinary victim simply does not know what happened in the design and production and marketing process. That's why the switch to this so-called strict liability or liability independent of fault was a bit of a revolution. But it's not, of course, that the manufacturer is liable for all wrongs, that all harm that the product may cause. Manufacturer is liable only for those harms which result from a defect in the product. So getting rid with the fault requirement, with negligence requirement, makes the concept of defect crucial. So in order to understand which scenarios result in producer's liability and which do not, you must know what the defect is. And that's the most challenging part of drafting our product liability law. There are various concepts of defect. And the 1985 directive adopted something which is close to the so-called consumer expectation test, because it says that a product is defective when it lacks a safety which a person is entitled to expect. So a defect is a lack of safety which we are entitled to expect. And of course, it's an extremely vague definition because the law does not say what level of safety we are entitled to expect. So in my view, it's a tool of shifting the burden of this decision into the judges. So the judge in a particular case has to decide whether this particular product meets the justified safety expectations or not. So the judge must first decide what are the justified safety expectations with result to products like that. And of course, as I said before, the moment at which the product was placed on the market is decisive for this judgment, for this assessment, whether the product was safe or not. And there are certain circumstances, or actually two circumstances, which exempt the manufacturer from liability. So even if the product was defective at this magic moment of putting it into circulation, the producer will not pay damages. First, if the defectiveness resulted from compliance with the law. That's pretty obvious. If there's a rule of law which obliges the producer to produce a product in a particular way, then he cannot be liable for producing it this way. That's for the coherence of the whole system. The second exemption is more problematic or more controversial. Namely, the producer does not bear liability if the defect of the product was of such kind that it could not have been foreseen in the light of current state of science and technology. So the producer can argue that that's true, the product is defective, that's true, the defect caused damage, but at the moment I put this product into circulation, the human knowledge and technology did not allow for me to discover the defect. So it was simply, not only for me, but in general, objectively, it was impossible to find out that the product is defective. And so, of course, that's not negligence, there's something different, but it's slightly similar to a fault-based liability. In a fault-based scenario, we would say, I acted negligently, so it's not my fault that the product is defective. In this case, the producer says, even if I exercised all possible care, using all human knowledge at this point of time, I would still have not discovered this defect. That's how it operates. So this is basically the state of the art. And what the new draft changes in regard of digital technologies, artificial intelligence, because that's our main focus. The new draft, a few words about the process. The draft was tabled by the Commission almost exactly a year ago, at the end of September 2022. Now it has been discussed in the EU Council, and the Council adopted so-called negotiating mandate. That is, the Council adopted its own amended, and I would say very soundly amended draft, which will be the Council position in the negotiations with the Parliament. The parliamentary committees will present their reports probably in October, so the Parliament will form its own negotiating mandate, and then we will have a period of so-called interinstitutional negotiations. Well, by all signs, it seems that the political agreement can be reached by the end of this year or at the beginning of next year, and the new directive is quite likely to be adopted in the spring 2024. And what does it say? The most important, the key change in the whole concept is that, and that's why I'm talking about it now, is that the definition of product, which at the moment is confined to tangible goods, to movables, the definition of product is to include digital manufacturing files, the CAD files, but that's not so important. These are files which are used in 3D printing and technologies like that. But the definition of product is also to include software. And this is a huge change in the whole, not in the concept, but in the way the product liability was applied in the European Union for the last less than 50 years. Because by adding a software, so something which is intangible, immaterial, to the scope of the application, we face 3 or 4 major questions. First, we have to define what the software is. The EU law at the moment is quite comfortable with using the term digital content. The digital content is present in a lot of directives concerning consumer law, sales of goods, and so on. But the digital content is a too broad concept for the purpose of liability, because digital content actually is everything which is in digital form. And we are talking about something which is first capable of causing, or at least potentially capable of causing harm, and secondly, something which should not consist in a pure information, because introducing liability on someone who generated information for inaccuracy in that information would be a step much too far, especially in the light of the EU values, freedom of speech, freedom of press, of media, and so on. So we should not end up in a regime where somebody is strictly liable for falsity of information. Of course, it will result in a chilling effect, and it would harm the creating and disseminating of knowledge. That's why the concept used here, the notion used in the draft directive is not digital content, and it's software, and it's explicitly explained in the draft that it does not contain pure information. That is, it does not contain the content of a digital file, nor the source code. Neither the source code nor the content of a media file or a film or a music file. None of this is a product, but a software that is something which operates the product, something which puts the thing in motion, something which we call functional software. This kind of software or this kind of digital products are products for the purpose of the directive. So this was the first challenge, how to broaden the scope of the directive into a digital world without going too far. And this is to be achieved by the concept of software as opposed to the pure information. And the second challenge is that when we enter into a software product area, there are different ways of delivering these products to the users. The traditional product, everything is simple. Produce it in my factory, sell it to the wholesaler or directly to the user, and that's all. With software, it's a bit more complicated because, of course, I can sell it in a traditional channel, either online or on a tangible carrier, which is quite rare nowadays. But I can also make the software available in the cloud. So the software is in the cloud, and if somebody wants to use it, to buy it, can download it to his computer. And also, I can also make software available for use without delivering it to the client. That is, the software is in the cloud, and somebody who wants to use it basically sends his data to the cloud and receives the outcome. That's a number of computer programs operate this way now. that we do not download them, we use them when they remain, so to speak, in the realm of the producer, under the control of the producer. That's why the new draft gets rid with the idea or the notion of putting into circulation, because it's too narrow for these scenarios. And in place of putting into circulation, in order to encompass all those scenarios, including software as a service, there are two new concepts: placing on the market, which is similar to the traditional idea, putting into circulation, but also putting into service. So there are products, there are goods which are not placed on the market, but they are put into service, and the public, or at least some people, are able to make use of those products without getting them either physically or getting them in a digital form. And the third challenge is that the software may be sold separately. A product as such, software is a product, but software also is an element of a physical product. That's actually probably the practically more important part. That is, the producer manufactures a product, which important feature is that the product is run by a software. And of course, a bug in the software may cause the product malfunctioning, and malfunctioning of a product may cause damage. We can think about a lot of medical devices, which are small computers with a lot of advanced software in it. So there was a need to think again about the concept of the component. I said before that the producer of a defective component nowadays is liable for a damage caused by a final product. So the lawmakers had to adopt the same thinking into the software sphere. That's why the new draft imposes liability first on a producer of a software which is so-called intangible component of a material, tangible product, but also imposes liability on someone who delivers so-called related services. That is, software services, digital services, which are integrated or combined with the product so that they are necessary for the product to operate, to perform its function. Maybe not to operate, just to perform at least some of the product's function. And this is something really new, because traditionally the strict liability was limited to products, that is, to something which is somehow delivered, which is on the market. And in this case, we are making service providers strictly liable, but only in case of those services which are software digital services necessary for the products to operate. And the fourth challenge and the fourth important piece of this new draft is that software is subject to changes. This is something we all know, that either software sold as a product, standalone product, or software which is a component, digital component of a tangible product, is constantly updated, upgraded. And of course, updates and upgrades have an impact, or may have an impact, on the product safety. And the problem it causes is that the old concept of producer being liable for a defect which existed at the moment the product was put into circulation is outdated. Because as long as the producer can update the software, or somebody else, with producer's consent, can update the software, the producer still exercises a certain influence on the safety of the product. And it would be impossible to allow the producer to free himself from liability by saying, well, this product was okay when I sold it first. Of course, later on, I changed the firmware, and bad things happened. But at the moment I put it on the market, it was okay. That makes no sense anymore. That's why the new draft introduces a concept of producer's control or manufacturer's control. As long as the product is under manufacturer's control, that is, the manufacturer is able to update, upgrade, or authorize somebody else to update and upgrade software, all the damage which is caused by those changes in the software are in the sphere of producer's liability. So we sort of extend the liability in time beyond the moment of the first putting the product into circulation. As I said before, the main feature, the cornerstone of this law is the notion of defect, and the lawmakers decided, or the drafters decided, not to change the general idea of defect as something, as a lack of safety the public is entitled to expect, but they added a lot of guidance, a lot of hints for the court as to how to assess defectiveness in the digital environment. And mainly, it stresses the need to take into account machine learning, so the possibility of a product to change its behavior as a result of interacting with outside world, to take into account the network nature of modern products. They are interconnected, and one device influences the operation of the other. So it is important to assess whether this product in question was safe, also safe against the influence that other products may impact the other products may have on it. These are the main, from the perspective of digital product, these are the main, most important guidance, most important tweaks to the idea of defectiveness in the new draft. And with regard to compensable damage, the draft not only, as it was before, allows for personal injury and damage to consumer property to be compensated, but also allows for the claimant to claim for compensation for a loss or destruction or and so on in the property which was not used solely for business purposes. It's a slight change, but it's a change which makes so-called mixed-use property, and there's a lot of it nowadays. We use our tools, our mobile phones, our computers for both professional and private purposes. So this little change makes all those mixed-use property protected by the product liability, whereas it was excluded. It is excluded as of now. And another important change in the notion of compensable damage is that damage to data is to be compensated. This is controversial, and this is one of the parts on which the European Parliament debates whether it's in favor or against this change. But the idea is that if we suffer damage which does not concern our physical being, and it does not concern our material, tangible property, but it concerns data. So, for example, I have movies stored on my hard drive, or music. I've bought high definition files. I have bought for quite a lot of money, and it gets destroyed because the hard drive was defective. Then the question is whether it is a compensable damage or not. The question is open under the current directive because the text is unclear in this respect. And the idea of the lawmakers is to make it covered explicitly in the new law. Does it solve the problem? Not necessarily, because even if we accept that loss to data is a compensable damage, then we have to quantify the loss. So in order to claim damages, we must prove what was the value of the file that was corrupted or destroyed, which is not always obvious. Sometimes those files are replaceable at a low cost, and there's no damage. But if they are irreplaceable, then the question of loss arises. So these are, I think, the most important parts of the draft as far as the digital technology and artificial intelligence is concerned, there are some other changes which are equally interesting but not entirely related to the AI. Something which is important and I think innovative to some extent and somehow connected with the issue of digital world is that there's an attempt at making the online platforms liable. So those platforms which allow to contact seller with the buyer, they do not supply the goods themselves. They're just a marketplace where the buyer meets the seller. If the idea in the draft is that if such a platform results in an outside product coming into European Union, and if a platform operates in a way that it creates an impression on an average consumer that actually the platform is a producer or the platform exercises control over the producer, then the platform operator is liable as an importer in a similar way. So that's not entirely relevant for our main topic, but I think it's quite interesting enough to mention it. So to sum up, because my time is almost over, to sum up, I think it's a good example of taking an old piece of legislation and taking some good and working quite well concepts, applying them in a new field, in a innovative, but also in a sort of safe way. So we're not reinventing the wheel. We're taking the device we already have and trying to apply it into, to put it into a new use. Thank you very much.
Dear Pьотr, thank you for all-encompassing picture of European Commission approach. We have now time for one short question before Natalia introduces the next speaker, and maybe we will have some time after both presentation to questions to both speakers. Do we have a short question?
I do. I do.
Me too. Okay. Okay. That's your question, Natalia.
Okay. Thank you so much, dear Pьotr. It was really very interesting. It was the whole lecture on these new approaches to PLD, right, and how to reform this, and not only this product liability directive, but some, attached issues. I'm sorry, I need to turn off the I'm sorry, I'm here again. Okay, so my question is the following. So as I understood while reading the project on PLD and this project on AI Liability Directive, while behind the AI Liability Directive, there is a fault-based liability approach, right? Behind the PLD project directive, there is a non-fault-based approach, right? So the Commission decided to leave this non-fault-based approach behind the PLD. But the question is, what do you think? Is it fair? Is it justified to make this contrast between these directives? Because, well, it is explainable that when we are talking about AI applications and AI systems and how they can make some damage to persons using them, yes, maybe it is explainable to say that we should only require some compensations for damages when there is a fault of somebody who uses the AI system or who produces this AI system. So this is explainable. However, on the other side, on the other hand, it is also clear that the risks of maybe malfunctioning of AI or doing something wrong by AI is higher because it can be unexpected. It can go beyond what is allowed to the AI system and start thinking on his or her own. I don't know how to explain the personality of AI, but let's say so. It starts doing something wrong on its own. And here we have this fault-based liability still. And in just when we are talking about simple products, even if they contain some software, like a simple algorithm, not being an AI system yet. So here we have this non-fault-based liability still. So do you think this is justified? Do you think this is fair? What is your opinion on this issue?
Yeah. Thank you
so
very much. It's an excellent question, and actually it's very much in line with what I think about the second proposal. But I wanted to leave the discussion about the second proposal to Riccardo. But my personal view is that first, for the practical and political reasons, it was much easier for the European Union, for the European Commission, to propose a non-fault strict liability regime for producers, because we already have a strict liability regime for producers. We're only enlarging its scope of application to digital products. So it's a small step, not a revolution. Whereas with regard to operators, introducing a strict liability of the operators would be a very strong step into the member states' tort laws, which member states are usually not very happy about. Because the tort law plays a special role in every system, and tort law plays a special role in heart of every lawyer, because we always believe that our tort law somehow expresses the way we see society, the relation between people, and so on. So making this step by the European Union would not probably be very welcomed by the member states. But I would say the Commission understands the limitations of a fault-based liability in case of operator, but left it to the member states for sorted in the first place. And just 1 second, because I don't want to deprive Riccardo of his opportunity to speak, but just my personal view is that the operators of high risks AI should be strictly liable for damage, not fault-based liable, but strictly liable for many reasons, but one is most important, that it's extremely difficult for the victim to prove the fault of the operator, because a fault is a personal circumstance. So if I want to claim damages from somebody, I have to first establish the standard of conduct he should have adhered to, and then to explain when he did not adhere to the standard of conduct. And in most cases of using the AI, the reply of the defendant will be simple. I used the best software available. I'm not at fault. I acted diligently. Well, the software had its bugs. The software malfunctioned, but that's not my negligence. I did what I could. So that's why I think the fault-based liability is not the road we will bring us any further. Thank you.
Thank you so much. That's really very interesting. And yeah, I also thought about that this fault-based liability may have been the kind of consensus between member states. So that is why they decided just to leave it as it is easier. So something like that. Okay, thank you so much. So Julia, do you have any other questions, or should we move to?
I left them for the next time after the next presentation. So please invite our next speaker.
Okay, thank you so much. So now I'm going to introduce our next speaker, my dear friend, Professor Ricardо Pazosa Castro, who is an assistant professor at the University, Comillas Pontifical University, at the Universitat Autónoma de Madrid, and assistant professor at Comillas Pontifical University. I'm sorry if I pronounce it in a not correct manner. I am sure you can pronounce it much better than me. I'm sorry. And he currently takes part in research project which is called Consumer Protection in the Digital Era. So Riccardo is going to continue talking about liability of AI, right? And the concrete topic of his presentation and his speech, I think it is better to leave to him to explain this topic, right? Because it will be concerning the burden of proof and concerning this AI Liability Directive, which was recently introduced in the European Union. So, Professor Riccardo, the floor is yours, and go ahead.
Thank you very much. It's a pleasure to be here with you, even if it's not in person. I hope we can be together very soon. Thanks for inviting me again, because I was in 2019 with you in Kharkiv, and I had a great time, so thank you very much. So my topic is related to the burden of proof, yes, for damage caused by artificial intelligence system. And I wanted to talk about the proposal for AI Liability Directive, and I wanted to introduce this proposal. So it's not only to say the content or the provisions, the content of this proposal, but also the background, the problem that we saw, and why we did decide about regulating these or taking some actions. So this proposal is part of a wider project or a package consisting of 3 streams. One is the Artificial Intelligence Act. The second would be a revision of certain standards for products related to safety, in particular the Product Liability Directive. And this would be the third stream of this package. So rules to address liability related to AI systems. And the legal basis for this would be the establishment and functioning of the internal market. So the starting point, or the regulatory problem that we saw, that we identified, and that we are trying to correct regarding liability, is that many companies are not willing to enter new markets or use artificial intelligence when entering new markets due to the divergences between the applicable law in different European countries. So it is reported that liability is the most relevant external obstacle for this. 43% of the respondents in the public consultation asserted that. So we think that if we correct this, more companies will use artificial intelligence in their services and products. And if we pass this rule, also potential victims will be better prepared, better protected. So, of course, the impact of this legislation is not the same for every country in Europe. It's not the same when you are surrounded by many other countries and your economy is highly dependent on exporting. For those companies, it will be very important. For other countries, it will be less important. So obviously, the effects are not the same for all countries. I always tell this anecdote when we organized in Santiago de Compostela, my alma mater, so north and west of Spain, just above Portugal, in the Galicia region in Spain. And we organized a conference, and 120 people came from different parts of Europe. And one colleague said to us, the organizers, that it was great because after all, we were in the periphery of Europe. So bringing together 120 people was really great. So what I mean is that obviously this proposal has not the same effects for, let's say, France or Germany or other countries more in the middle of Europe and surrounded by several countries with different legislation than for other countries which are farther. So cross-border trade is important for us, but maybe it would be less important. So you always have to take into account these divergences and the interests of different countries. That's very important to notice in the EU. Of course, and this is another joke, but it's true. You will tell me, well, Spain exports a lot, even their products, its products come to Ukraine, because back in 2019, during the gala dinner, yes, the wine served came from Spain, so good choice. Yes, we export, but in other markets, it might not be the case, or the same, at the same level at least. Another issue that I wanted to mention regarding the regulatory problem is the black box problem. This is quite typical. Everyone that has worked on these matters of AI knows this problem of complexity, autonomy, and opacity that makes it difficult for a victim to claim damages, to be able to prove the requirements for a successful claim. So we are trying to correct these problems, or these gaps, shortcomings. I would like to mention as well the principle of subsidiarity, because I think this is pretty important in the digital context. A disclaimer, I'm not saying that we shouldn't regulate, of course, AI at the EU level. I'm not skeptical about these proposals. Yet I think we should take into account just another part of the picture that there is, because it's true that we want to have European sovereignty in these issues. That's a problem, because as the saying goes, China builds or produces what the US designs, and then we regulate it, but we don't create, we don't produce. So we're just at the last stage, and that means we are dependent of what we are given. We don't have something, let's say, adapted to our philosophy or our values. So it's true that we need a European approach on the area, but subsidiarity says that you can only regulate something at the EU level in cases of shared competences, when the objectives of the treaty cannot be sufficiently achieved at the national level, or regional or local, but that they are better achieved if the regulation takes place at the European Union level. So probably the ultimate stage is for the EU to regulate the issue and to have an European approach. But my question, and I'm not saying this is my personal opinion, it's just something that we might take into account, or that we might introduce into the debate, is in these cases of digital aspects that we don't know very much how they work yet, because we are in the beginning. So we don't know exactly the right balance or the effects of legislation, the externalities, the backdoors. So would it be as catastrophic as one or me may think at first sight, to have some competition, regulatory competition in the beginning, just as a sort of test, some sort of trial and error processes, to know afterwards with different experiences which is the right way to approach this? So I'm not saying in this proposal subsidiarity is not respected. I'm not saying that the EU should not intervene. It's just that some details or some aspects in certain matters, in these cases, it might be interesting to have some trial and error processes, checking whether different countries would get to the more or less same point by different roads, maybe, checking what are the problems, how we solve them, and did it work what externalities came out. And that's something the EU can do. For the US, it would be, I think, more complicated. And for China, it would be impossible. So maybe that's something that we can use, this regulatory competition in the good sense, to get to the point of cooperation in the end and have a stronger European approach. So that's just one thing that I wanted to comment in connection with the subsidiarity principle, because in the proposal it was said that subsidiarity was respected in this case because we have fragmentation and there are countries willing to take action and further divergences would come out. So I'm not sure whether these divergences would be bigger than they are now. I'm not saying they wouldn't be, but I'm not sure they would. So it's something just to add to the debate. I'm not taking any stance here because it's a very tricky question, but just to raise another point that could be interesting within a discussion. So the policy options that there were for solving this problem, according to the proposal, there were 3 options. I think, truth be told, there were just 2, because the first policy was we ease the burden of proof, period. The second policy option was we take these measures to ease the burden of proof, plus we harmonize strict liability rules for certain profiles of artificial intelligence of high risk and mandatory insurance. So we went quite far. And the policy option 3 was we ease the burden of proof and we reassess the thing after a few years. So for me, policy option 1 and 3 is the same, because nobody can seriously believe that we're going to take a stance and then just let it happen. And if we see that something is wrong, we're not going to reassess it. So for me, it's just 2 options. Policy option 3 was chosen. So it's a staged approach. So we are going to take a couple of measures to ease the burden of proof, and then we're going to reassess whether further more intrusive measures are needed. The proposal also said that a non-binding instrument was considered in the beginning, but it was discarded. And I wanted to read this paragraph because it tells us something about the EU that I think it's not very positive. So when I read this, I was quite sad, actually, because it says that while a non-binding instrument would be less intrusive, it is unlikely to address the identified problems in an effective manner. The implementation rate of non-binding instruments is difficult to predict, and there is insufficient indication that the persuasive effect of a recommendation would be strong enough to produce consistent adaptation of national laws. So as Professor Machніковські has just said, it's true that we are all attached to our tort law systems, but it's also sad that the EU admits that if it's non-binding, the member states will not follow or will not sufficiently follow, because it reflects, in my opinion, some kind of not trusting the EU, even if in the EU there are representatives of the member states. So do we really have to mandate something to persuade member states? Probably yes, we need it, but it's sad. I would like it otherwise. I would like more confidence. So the non-binding instrument was left. There's something that I did not see in the proposal, which was something related to proof by indicia. And why am I raising this? In the product liability directive, of course, you need to prove the defect, the damage, causation between the two, but sometimes it was already difficult with the non-digital products. And the Court of Justice said that the directive did not prevent a national law system from finding causation with a set of sufficiently precise, consistent, and specific indicia. And this matter of indicia is also used in restrictive measures, also called sanctions, but which are not of punitive nature. For instance, in the context of the common foreign and security policy, you establish a restrictive measure, for instance, freezing of funds, and sometimes the actions that you are trying to correct, you are trying to nudge the person into behaving otherwise through these restrictive measures. Sometimes you do not have boots on the ground. You cannot know what really happened. So you use indicia, sufficiently precise, consistent, and specific, to find causation. So in this case of artificial intelligence, it is another instance where finding causation is difficult. So maybe we can do something about that through this idea of indicia, saying, okay, in this situation of damage caused by by artificial intelligence systems, we're going to harmonize. So all countries in Europe will have to admit the proof by indicia. So that would make it easier, and that would be another possibility. And this standard is not unknown to the EU in private matters through this product liability case law, and in EU public law with restrictive measures. So that's another point that I would like to raise. So the scope of the directive. So now we're going into the two provisions that reflect the content of this proposal, and the two aspects that we are trying to manage to make claims easier. So first of all, it is the disclosure of evidence to make it easier for a claimant or a potential claimant to fulfill the conditions, the requirements necessary to bring a successful claim. And then the burden of proof. We are acting on the burden of proof to make it lighter, and all these in cases of non-contractual fault-based liability. So as you mentioned before, Natalia, this directive takes us starting point, fault-based systems. And another aspect, this directive is applied only for damages that occur after the end of the transposition period. So first of all, disclosure of evidence. So the basic idea I have told you already. So it's difficult to have the necessary data to sustain a claim when you suffer damage by a system of AI. So we're trying to give to the victim the necessary information for that. So national courts are to be empowered to order disclosures, either upon the request of a potential claimant who has already asked for the information to the producer, to the person who is subject to the same obligations as the producer, or a user of an AI system of high risk. And also a claimant that has already fulfilled a claim may request some information to base the claim and to be better prepared. The goal, the ultimate goal, is to set the victims of AI systems at the same level in terms of how easy it is for them to sustain a claim and to to do it successfully as victims of non-AI caused harms. So you can request the evidence you need to base your claim. It is important to mention that if you are a potential claimant, you have to have asked for that before. You can ask the court to order this disclosure. If you are already a claimant, then you can only apply, or you can only request these disclosures related or to people who are not defendants, if you have already tried to get the information from the defendant. Once you are a claimant, you also may request the court to order specific measures to preserve the information and the evidence you need. Of course, all these requests must be grounded, so the requests must be supported by facts and evidence sufficient to establish the plausibility of your claim, and the request for preservation of evidence must relate only to the necessary and proportionate data. This is just not to disclose trade secrets or confidential information, or to handle that. So just the information you need and nothing else. Of course, if we were talking about the legal fragmentation and the legal uncertainty to know the law and to have to manage claims and disputes with tort law, which is not in line with AI, it is no less true that this criteria of plausibility of your claim is very open, very vague. Of course, what's necessary and proportionate, it's also an open notion. Finally, if this disclosure is not made, you can presume the non-compliance with a relevant duty of care. So the point of arrival is you are given the evidence, so now you have the tools to base your claim, or you're not given the evidence, and then the court shall presume non-compliance with a duty of care, which is relevant for the case. Of course, this presumption might be rebutted by the defendant. And this idea of presumption of non-compliance, obviously, it only affects defendants. So once you have this evidence, you go to the second important provision, which is Article 4. And this is about a rebuttable presumption of a causal link in case of fault. So the basic idea is that you have a presumption to ease the burden of proof, but still the victim will have to prove certain things. So this is not touching the notion of fault. So fault is to be understood as it is in the applicable national law. The concept of damage as well, it depends on the applicable national law. The burden of proof, which party has the burden of proof, that's not touched. The degree of certainty, so the standard of proof, is not touched either. So these things will still be subjected to the national applicable law. In this case, it's just a presumption for a specific aspect. Normally in tort law, you would say the victim must prove an action, a damage, causation between the two, and eventually fault if it's a fault-based system. Now you must add another layer in case of AI systems, because you have to prove that the wrongful act or the non-compliance with the duty of care by an actor has given rise to a certain outcome in the AI system. So you're not presuming causality between the outcome of the AI and your damage. You're presuming causality between the non-compliance of a producer, of a person who is subject to the same obligations as a producer, or a user, and the outcome of the AI. So this presumption will work only if 3 conditions are met. This is to begin with, because this is a quite complex provision and you have to go step by step. So first of all, in order to apply the presumption, there are 3 conditions to be made. First of all, you need fault, because the whole liability directive is thinking about fault-based systems. So you need fault. Either the victim proves it, or you presume fault with the previous provision. So because of not providing the relevant evidence. Second, you need to establish that it is reasonably likely, based on the circumstances of the case, that fault has influenced the output produced by the artificial intelligence system, or the failure of the system to produce an output. So it can be considered reasonably likely. I think this is connected, or not so far from the indicia that I mentioned before. So that you have a set of indicia, and out of this you can rule that it is reasonably likely that fault has influenced the outcome, or the absence of an outcome that should have been. And third, the claimant must prove the causal link between the outcome of the AI and the damage. So again, this is just a presumption between the non-compliance of the actor who handled the AI system, and the failure of the AI system, not the damage. That should be proven by the victim. Once you have this, you must differentiate between 2 cases. And these 2 cases relate to the first of the conditions that I mentioned before. So the aspect of fault. So you have 3 conditions. Now we are entering into the first one. And you must differentiate between, on the one hand, claims brought against the provider of a high-risk AI system, or against a person subject to the provider's obligations, and on the other hand, claims brought against the user of such systems. So first of all, if you are suing the producer or a person subject to the same obligations, the failure to comply with the relevant duty of care must be related to certain aspects. So it's not every aspect, just certain ones. So this is another sort of restriction, but this can be easily explained because of the obligations set out in the Artificial Intelligence Act. So you have to connect both texts. So what are the aspects that must be connected with this non-compliance? Well, for instance, if the training, validation, and testing data sets of the AI system do not meet the quality criteria of the AI Act, that will be one possibility. Second, if the AI system is not designed and developed respecting the transparency requirements. That could be another possibility. If the AI system is not designed and developed in a way that allows for an effective oversight by natural persons, that would be another possibility. So fault must be related, or the non-compliance must be related with one of these aspects when you are suing the producer or a person subject to the obligations of a producer of a high risk AI system. Another possibility is that the AI system does not have the accuracy, robustness, and cybersecurity, which is appropriate, or that the necessary corrective actions were not immediately taken to withdraw or recall the system. So one of these 5 possibilities. If you are suing a user of a high-risk AI system, who is subject to the requirements of the AI Act, the non-compliance must be related to one of 2 possibilities. That this person did not comply with its obligations to use or monitor the system in accordance with the instructions, or when the user did not suspend or interrupt the AI system when this user was obliged to by the AI Act. Second possibility, that the user has put input data in the system which was not relevant for the intended use of the artificial intelligence system. So you have 3 criteria, just for a recall, 3 criteria, and out of the first one regarding fault, the provisions and relevant conditions of the AI are important, and you connect the duties of a person, be it a user, a producer, a person subject to the same obligations as a producer, with the failure or the non-compliance that they have incurred into. And finally, or just to come to the last point of the presentation, there are certain cases in which you're not going to apply the presumption. So you have 3 conditions, then 2 conditions of the first one, but there are situations where you cannot apply the presumption. And here you must differentiate between 3 situations, 3 scenarios. So first of all, in a claim for damages concerning a high-risk system, you don't apply the presumption where the defendant demonstrates that sufficient evidence and expertise is reasonably accessible for the claimant to prove causation. So in this scenario, the benchmark is if the claimant has sufficient evidence and expertise. If it's reasonably accessible, then the presumption does not apply because it's not needed. You would be able to prove causation without any further help. Second possibility, damages concerning an AI system that is not a high-risk one. In this case, the benchmark is different. It is not that the expertise and evidence is reasonably accessible. Here, the presumption will not apply if the court considers that it is not excessively difficult for the claimant. So, first case, reasonably accessibility. Now, if it's not excessively difficult, then no presumption. And last scenario, a claim for damages against a defendant who used the system for purposes not related to the trade or profession. So people who use an AI system in the course of a personal activity. So the presumption will apply only if the user of the system added risk. And what's that of adding risk? That's the underlying idea behind this rule. Well, two possibilities. One, the defendant materially interfered with the conditions of the operation of the system, or the defendant was required unable to determine the conditions of operation of the system and failed to do so. So the increase of the risk is due either to an interference, a material interference with the system, or that the user was able and required to determine the conditions, and they didn't do it, basically. So there's a higher risk, you added risk, so the presumption may be applied. And of course, last point, even if this was already said before, this is also a rebuttable presumption. So all this directive is based on rebuttable presumptions because it was considered to be a not so intrusive policy option, and the idea is to give the victim the evidence to base a claim that touches fault. And second, the idea is to ease the burden of proof with a rebuttable presumption of causality, again, between the action or the non-compliance and the outcome. Then, of course, you will have to prove that it was precisely the action of the AI system, the outcome, or the omission that caused your damage. So just to conclude, I have tried to give you an overview of this text, both conditions or content of the rules, but also the background, the regulatory problem behind. And I have been, I have looked a little bit skeptical, but again, it's not the case. It's just that I am giving you some food for thought, as it is usually said, because there are some points that are open-ended. There are points which are not completely clear, and there are aspects that we can always discuss on whether the road is the proper one or not. The goals, I think we all agree on them. And it's just a matter of finding the best means to get to where we want to be. And in this debate, you can always reflect on small shortcomings, which might not be so, or externalities that we haven't seen in the first place, or like I said, maybe fragmentation in this case could not be as bad as it usually is. So I was just a little bit, I don't know how to say, critical, but just to foster a discussion on the matter. I don't have the right answer. So we need many voices as possible. Thank you very much.
Thank you very much, dear Professor Riccardo Pazos. It was really a real pleasure to hear this, again, whole lecture on all aspects of this new introduction, new directive, new proposal for AI Liability Directive. So this was really, really very interesting for us, and extremely interesting for us as for the lawyers of Ukraine, which recently obtained the candidate status of the EU member state. So yeah, this introductions of the pieces of European legislation are really extremely important for us, for the understanding of this legal system, of this legal environment, I should say. So thank you so much. And now we are open for the discussion. We have some minutes to discuss the issues which were raised during this section of our panel discussion, and I will not make a kind of a monopoly on questions. I will let our participants, first of all, to ask their questions to our speakers.
So I will take this opportunity.
Okay.
I have two questions, short questions for both our speakers. First one, should we have special rules to products of generative AI, like, I don't know, ChatGPT of the next generation? And the second question, there was an approach of European Commission to focus on high-level AI risk, especially in a future AI Act, but there are also Parliament and Council approaches which are slightly different. So how this sectoral regulation, both directive, will be harmonized with AI Act when it comes to action?
I may start. But the problem with generative AI is that actually, to my mind, it may be a source of someone else's harm if it's used in a wrong way. So I wouldn't locate the liability in the creator of the program or the one who makes the generative AI or ChatGPT or whatever else available, but only one who uses it. And then we face the two problems. One is quite easy to solve. That is, because the scenarios which come to my mind is that somebody creates a fake text, fake information, something which impersonates somebody else, or presents itself as a fact which is not a fact. So it seems to me to be easy to prove the wrongfulness and probably fault on part of the user of the AI. So I don't think we need a special rule on that, and I don't think, as I said before, we need a special rule for the producers or developers of the AI, except that the generative AI, so to speak, allows to reach the result it shouldn't never allowed to reach. So I assume that there are some limitations on what these programs can do or should be able to do. And this is the case where I think the producer or developer should be liable. But that's probably, it can be done. It should be covered by the product liability legislation. Because when the generative AI software allows to produce a text which is racially biased and so on, to me, it's a defect of the program. It's not only a wrongful use, but it's a defect of the program. So I would say that the rules which are now on the table should be sufficient. With regard to high-level AI risk and other approaches, I must say I'm convinced by the approach taken by the Commission that we should focus only on the high-level AI and with all the, because AI is defined very broadly in this proposal. So we must, if we want to regulate in a way that we first restrict the application, or restrict the market, and then we make people liable for what the AI did, we must restrict it not in terms of definition of the AI, but in terms of the use. And the high risk concept is based mostly on the, as far as I understand it, it's based mostly on the goods or interests protected, or the interest which can be interfered with by the AI. So it's more the way we use it than on the software itself. And I think this approach is promising also if a member state would be interested in introducing a strict liability of users or operators, because it's easier to say you're strictly liable for what your AI in your hands did. When you use it in a context which is classified as a high-risk AI under the regulation. So I think this concept opens many possibilities also for national legislators. I'm not sure if it answers the question, but that's what comes to my mind.
Yes, thank you for this broad answer, because I agree actually with this high risk focusing, because that's reasonable to have it.
Okay, maybe someone else has questions. Well, if no one does, I would like to ask a question. I don't know whether it will be short or not, but so I wanted to deliver it to both of our speakers. I don't know where I read about this approach, maybe just in some academic literature, but I think that maybe I saw it in some communication from the European Commission to Parliament or something like that. So the approach was that maybe we should have a kind of an obligatory insurance for users or for producers of AI systems, and then this approach could erase all these problems concerning causation, concerning the burden of proof, and so on and so forth. So let's make something which will in itself erase all the problems which may arise on the side of the claimant, on the side of the victim of this or that malfunctioning of an AI system. So is it an option in your opinion? Not to, go into all these details of who particularly was in fault of malfunctioning of the AI. Was it a user or was it a provider of the AI system? But just to say that, for example, providers are obliged to conclude insurance contracts with some insurance companies, as we have it with the liability for damages at the traffic, right? So maybe this is an option. What is your opinion on this issue?
May I?
Yes, sure.
So it is an option, absolutely yes. It's a possibility, it is quite alluring, and it has obvious benefits. I mean, when we are driving safe, or we consider us to be safe, because if something happens, we know there's insurance that will cover for that, or at least for certain damages, not for all of them, depends. But at least for civil liability with third parties, yes. So if another one hits us, we know that we will be covered. So that's good. On the other hand, I always think, what will happen when I see somebody doing whatever in on the road? I always think, what would happen if this person knew that other drivers may or may not be insured? Would we be more cautious while driving? It may be true, or it may be not. I'm not sure. I'm just raising the point. Again, I don't have the answer, but I can ask a little bit myself. I see people doing certain things, and I always think, or either they don't think at all, or they know that they are insured against all risks, so they truly behave in this way, because if not, this is completely impossible to understand. So there's always this modal hazard problem, that when you get insured, you're less cautious. I mean, I tell my students with my cell phone, my first cell phone never fell in I don't know how many years. Then with the new cell phone I bought, it never fell either. Then I bought one, and I bought also a protector. And now it happens that it falls all the time. I mean, I think, I don't know to which extent that's connected, but it happens. I mean, the phone I have now has fell to the ground, I don't know, maybe 7-8 times in 2 years, while in 10 years before, it had never happened. So moral hazard exists. Then there's another issue with insurance. And again, I'm being skeptical, or I'm trying to raise the weaknesses because the strong points are very obvious to anyone. So I think it's more useful to point at the possible shortcomings. Second question, it's very good to mandate insurance, but somebody must offer insurance. Who is going to offer that insurance at? Which are the premiums? Because there are insurance companies that will not dare to offer policies against certain risks, or only charging a lot. So of course, mandatory insurance is fine, but from a practical point of view, when you analyze, when you make the taxonomy of insurable risk, from the practical point of view is you need someone to offer insurance to you. Otherwise, it's not possible, and not charging a lot. So that would be the problem, how much you are charged for it. If somebody offers insurance in the first place, and then how that might affect the behavior of people. But those are the shortcomings. The obvious benefits of insurance are there. So of course, advantages, there are many.
Okay, thank you. Thank you so much for this nuanced analysis, because you pointed out both benefits and some disadvantages of this approach. So thank you so much. Maybe someone else has some questions?
Maybe yes, but we don't have time for this. You
Yeah,
will be a good
sure.
moderator, and I will be a bad one. And we have a short discussion also in chat because Diana and me discussed this option about to have some insurance fund in which some companies will contribute before introducing AI into market. That was one option that was discussed. Okay, sorry for interrupting all of us, but I suggest to return 10 minutes past 11, yeah? Would it be okay?
Past 12, according to Kyiv time.
Past 12 in Ukraine, past 11 in EU, and I don't know how it will be in US, but very early. So in 12 minutes, we will go again, and now we have a short break.
Yes.
Thank you very much.
Thank you very, very much.
Thank you.
Wonderful discussion on AI liability. Thank you so much.
So that's time to return, and we will have now time for the discussion again. And I will pass the moderator power to Natalia.
Yes, thank you so much. Thank you so much, because we have an opportunity to introduce our next speaker, and our next speaker, guess who it is? It is Yulia, Юлія Размєтаєва. So she represents our university, Ярослава Мудрого National University, and also Уппсали University in Sweden. She is the head of European Fundamental Values in Digital Era, Jean Monnet Center of Excellence. She also is an associate professor at the Department of Human Rights and Legal Methodology at our university, and she is a visiting researcher at Uppsala University, and she is also my boss at our small center, of excellence. So I'm happy to introduce her, and the floor is yours. So welcome.
Thank you, dear Natalia. That sounds so strange to be a boss. But I will share my presentation now and hope you can see it. Yeah. I will try.
It would be better to to
Yeah, I
extend.
will try, but sometimes it doesn't work when it's in full screen format. But now I switch the slides and yeah, it works. Yeah, super. So in this part, we will have 2 short presentation and 1 standard presentation. So I will take my brief time to tell you that several days ago, United Nations General Assembly gathered in New York, and there were a special event titled Governing AI for Humanity. The UN discussed plan to shape the future of AI to have global oversight body and international AI governance. So a new UN agency probably will be required to help the world cooperate in managing this powerful technology. And sharing the UN concern, I will nevertheless not try to convince you of the danger of AI or to remind you that these technologies are developing at rapid pace and are not going to stop in the near future, which among other things promise us perfect generative AI quite soon. I want to walk through some aspects of how AI can affect justice and public power, public authority, looking at through the lens of values. And sometimes I will take some examples of court as quintessence of justice and parliament as quintessence of public power. So speaking about context of values, I mean in the first place, I mean human rights, democracy, and rule of law, this value triad that are shared in many legal systems and are also the basis of the European legal order. A more specific European context also include the values listed in Article 2, Treaty of European Union, and they need to adhere to them when it comes to artificial intelligence technologies. Also, the European Union approach include the importance to be grounded, AI to be grounded on values and fundamental rights such as human dignity and privacy protection. So let me take an example of human rights and then we come to justice. When we take an example of human right lens, we can see the impact of AI and we can see that AI could affect fundamental rights, the idea of human rights, in general, through the erosion of value bases and the recurrent to technological determinism and more utilitarian approach to regulation and practice. But also AI can attack individual rights in overt and covert manner. In addition, AI can and will have a combined impact, so affect several rights at once. For example, content moderation algorithms may affect not only freedom of expression directly, but also freedom of thought, religion, the right to non-discrimination, equality, the right of the child, since the algorithm in their design and use may be invasive, selective, promote polarization of opinions and dilute discussion, as well as generally contribute to the formation of certain picture of the world among users of digital context. AI can make a covert attack. It may track of personal biometric data, including micro expressions, tone of voice, heart rate, or temperature data. This opens up the field not only for an overly accurate picture of how a particular person breathes, moves, and lives, but also for planning a very targeted impact on this person if this data is used beyond a goal declared by public authorities. But by the same token, private actors can impact people extremely successfully. For example, fitness bracelets or rings to track heart rate and body temperature advertised, but companies provide them with extremely sensitive and intimate information. In addition, AI impact is profound impact. So, for instance, algorithmic predictions can undermine justice when they become part of judicial process, or can undermine democracy and openness when they seem to make public discussion about public decision unnecessary. Preemptive power of AI make possible both narrowly targeted and very precise intrusions into the sphere of life of specific person, as well as the governing of people who were algorithmically sorted into groups based on certain characteristics of these people. So let's talk about justice, and my presentation doesn't work again. I will try to, unfortunately, I need to stop share and share it again, maybe in not full screen regime now. There is a problem in Zoom sometimes with this. I want to talk now about justice and about principles of justice. There is no denying that AI in courts and public decision-making should be developed, taking into account the requirement of human rights, transparency, accountability, and should be built on diverse and protected data. However, when it comes to details and the actual embedding of principles into an algorithm, many questions arise. First and foremost, prior to programming an algorithm, a definite concept of justice is to be selected. And this is itself not a simple task. There are many concepts of justice and many debates around them. In addition, the question is who will choose the principles of justice that are embedded into AI. So choosing between Elon Musk and US Supreme Court, I would choose the court, but unfortunately, the influence of the former in AI issues is something greater that of the later. The owners of AI development companies also have the advantage that they implement AI super fast, and sometimes it is difficult to roll back the process even after a court decision that would include such a requirement. If the concept is chosen, a lot of collaboration would be necessary among the government, civil society, corporations, academicians. However, the stakeholders' thinking style are fundamentally different. A judge style of thinking is different from data programmers, so they literally speak different languages. Then, once the concept is chosen, the complicated principles are to be turned into lines of code, and then AI is to be taught to take decision which appears to be a next to impossible task given the ultimate complexity and intricacy of judicial decision making. People who apply concept of justice in courts and public authorities, and people who reflect on them and teach others, lawyers, philosophers, ethicists, learn and rethink their own approach all their lives. This includes the transferred knowledge, experience, some may even say the formation of sense of justice or ability to make moral judgment. So from the point of view of values, it's doubtful that the implementation of AI can be good for justice. There are advantages for this implementation, but if you take each specific advantage and look closely, they are not so obviously beneficial. As an example, one can say that AI is capable of making impartial decisions, and this is one of requirements of justice, but one should not forget about the problem of bias. Of course, human judge may and will be biased, but one can always talk to human judge and find out what the decision was based on, influence it. A judge is often known for his public opinions also. But an algorithm is impersonal and obscure, especially for non-programmer. It may and will be biased, but there is no one talk and no easy way to figure out with possible misconceptions. Then we cannot guarantee then AI that will be involved when applying justice will really understand the law and interpret law properly. AI is becoming more and more advanced in recognizing and extracting information from text, but if perhaps AI capable of analysis and synthesis, and therefore can claim at least partially to be an agent and even if it's purely rational agent. However, if the algorithm really capable of understanding, can algorithm extract meaning from the text? Yes, it can, and no, it cannot. It can understand the text meaning, find and analyze the facts. It cannot understand the text and cannot interpret the facts in the light of infinite number of contexts. In contrast, in order to determine what is fair decision when it comes to a particular case, human judges apply not only legislation and precedents facts, but also infinitely complex consideration based on their understanding of law and the experience of law, I need to say. In addition, the judges must justify the decision in such a way as to convince others to its fairness. And this is an important part of justice, all of this, human understanding of law, interpretation of law, and justification. Entrusting AI with applying the principles of justice in courts and public decision-making will likely lead to their uncontrollability, which is a threefold problem, actually. First and foremost, it might be difficult to control algorithms due to the speed of their development, as new technologies got deployed before it's clear what hazards long-term consequences they will entail. Secondly, AI is obscure. Its technicalities and incomprehensible things, they are incomprehensible for general public, and its complexity stands in the way of understanding its hidden mechanism. This render AI intangible, impersonal, and even awe-inspiring. Thirdly, AI has always been and will inevitably remain less controllable than other official entities responsible for implementing justice due to the private ownership of algorithms, their parts, or entire AI systems. And the dependence on public sector on private actors who create, modify, adjust, and maintain algorithms could be one of the scenarios that may have adverse consequences for the pillar of societies, for the fundamental human rights, the rule of law, and democracy. AI owners, for example, legally refuse to disclose source code, they're depriving users, including government organizations and institutions that may face emergency situations, from the opportunity to check potential discrimination, potential vulnerabilities of the algorithmic tool, investigate some security threats as well as technical errors. And such dependence may exacerbate by the monopoly position of some AI developers. Therefore, the tried and tested procedures of democratic control will probably not work in the case of AI. And one more aspect, I didn't vote for the algorithm, and it's already telling me what's just and what not. This reaction is expectable and explicable. The gradual, imperceptible, and profound penetration of AIs into public and private spheres of life has suddenly reached a point where they are literally acquiring legitimacy. The usefulness and necessity of AIs seem to no longer need justification. And because of this usefulness, people don't question their legitimacy. A continued intrusion of AI into both everyday tasks and justice system becomes irreversible because individuals already perceive them as part of the familiar landscape and an integral part of their lives, as well as society as a whole. It now appears next to impossible to separate the technology from humans and abandon the benefit that people have got accustomed to relying on. Indispensable appears to begin mean legitimate. Also, the formation of human system based on the principles of justice and values took centuries, and it's still ongoing. Most elements of these systems, legislative, executive, judicial power, include certain requirements of legitimacy. AI seems to have bypassed the requirement. For instance, Compass, that's a predictive algorithm in US courts, or system risk indication that were used by Dutch government to identify potential social welfare fraud. The requirements for institutions that people consider legitimate have been crystallizing over centuries, and despite strong checks and balances, the institutions are still far from the ideal model, and regulatory what I mean to say, we are still faced with the problem of justice in various jurisdictions, despite this strong checks and balances, despite this crystallizing process. And adding AI, which is already gaining legitimacy, and it's uncontrollable in many ways, only makes it worse. It is doubtful that algorithmic justice will successfully overcome both old and new challenges, and the already existing problems with justice will be just multiplied by not offset with emerging trials and tribulations. So the threats posed by AI don't and cannot mean we need to abandon AI altogether. Of course, it can create a lot of benefits. At the same time, it is necessary to take into account that we are not discussing some hypothetical distant future. We are live with AIs. And even if we think that that's a very philosophical questions, that's justice principles or so on, but that's real practical questions. I will stop here not to take more time. And if you have some questions, I will be happy to answer.
Thank you so much. Very interesting, and the extended, very broad topic was just now raised by Julia, and maybe someone has some questions concerning this topic, concerning this issue. Again, first of all, we welcome our guests to put their questions, and only then afterwards we will put ours. So it seems that no one wants to put the question right now, so maybe I will do this. So Julia, I found that I really liked the statement on your presentation where you said that there is a phenomenon of dependency of public power on private algorithms, right? So this is an issue which is now being actively discussed. And recently I read an article by Ilaria Pretelli, who is a specialist in international private law, but she called modern digital platforms new functional sovereigns, so a phenomenon of platform sovereignty. So what am I hinting at? Do you think that companies who produce AI systems can become a kind of new sovereigns when they produce the algorithms which further are used by public power institutions in their activity?
Thank you, Natalia. That's an excellent question. But why they will? They are sometimes. They act like states in some context, I need to say. And some big tech companies are already gain power really close to public power. For instance, digital platforms manage these issues of human rights, and they impose their understanding of what freedom of expression means. So that's not approach based on human rights as I see this approach. That's some alternative approach. And moreover, who decide how they interpret this freedom of expression, for instance. So probably that's some managerial managers of this company. And it's also not how it should work.
Okay, thank you so much. Yeah, well, in fact, I found this idea very interesting and very descriptive, the idea of kind of a functional sovereignty, because, yeah, really, when we are talking about platforms who currently are using algorithms and AI systems actively, yeah, we can say that these are closed systems and closed kind of environments when we have everything at hand and regulation as well. And now when we are talking about extension of algorithms and AI systems to public power, when we say that public power will be actively using and currently uses AI systems when deciding on this or that issue, this issue becomes more and more obvious, maybe, and important to discuss. Thank you so much. Maybe
Yeah, I agree. We need to plan another discussion, maybe about sovereignty of digital platforms. But now I want to give the time to the next speaker, and I'm happy to introduce my dear colleague Sandri Fribaig. She is an associate professor of private law and senior lecturer in private law at the Faculty of Law in Upsala University. She is also a principal investigator in the Artificial Public Servant project, and her current research is focused on how AI can be used to make decisions and what should be the responsibility for decisions and actions made by AI. But she will talk now about protecting human rights in CAI Convention. Dear Sandra, the floor is yours.
Thank you so much, Julia, for this very nice presentation, and thank you for giving me the opportunity to participate in these fantastically interesting discussions. I really enjoyed the just previous discussion between you and Natalia, and we've talked a lot about these things, of course, previously as well, of sovereigns, social media platforms becoming great sovereigns with the financial power and power in total, which more or less corresponds to countries, and how we actually deal with liability issues in those matters as well. But as you said, Julia, I'm going to redirect focus to another part of, well, one way of trying to deal with these new type of algorithmic processes and how we ensure the protection of human rights in this context as well. So I'm going to see if I can share a screen with you. I hope I have the competence to do that. Let's see if you can see this one.
yes, we do see.
Yeah, okay, so there it is. I'm going to now talk about the CAI Convention instead, and this probably is familiar to quite a few of you, but I thought that I would give a short presentation of this type of regulatory tool that is now being discussed, and a bit in contrast to how matters of AI is being regulated on the level of the European Union might be of interest, and hopefully give food for thought for further discussions as well. The CAI Convention, just briefly, is then something that is being formulated and is at present being discussed within the Council of Europe. And in contrast to, just to give the constitutional background more or less to what kind of organization we have to deal with here, is it's not as the European Union, some sort of organization that we have had transferred powers to, but is a pan-European human rights organization that has also in the past been very active and is still when it comes to fight against racism, cybercrime, and other issues as well. And it takes a great interest and has as its fundamental goal, you could say, to promote freedom of expression, gender equality, cultural diversity, etc. So the focus is very much on human rights, democracy, and establishing and protecting the rule of law in different type of instruments that the Council of Europe puts together. So in September 2019, it was established an ad hoc committee on artificial intelligence, since the need for further discussions on these matters were becoming quite urgent. And the task for this ad hoc committee was to at first see if it was possible at all, if it was feasible to establish a legal framework for the development, design, and application of AI. And in that setting as well, which I always find very useful, to actually see if there was a need for a new instrument. It's so very often that we just assume that some new technological challenge automatically leads to the need for new instruments, and at the same time not sort of first of all looking at what do we have, and does these legal instruments actually take care of these new technical dimensions to legal problems. But they did this in the ad hoc committee as well. They investigated the need for new instruments with, of course, then the human rights, democracy, and rule of law guiding principles for their work. So they then ended up with a report, and on the basis of this report, the Council of Europe established a formal committee on artificial intelligence, the CAI committee, which has its mandate running from the 1st of January 2022 until 31st of December 2024. And the task is to draft up a convention to be ratified by states. This is, as I just mentioned, no transference of legal competence, in contrast to the AI Act, which is being designed and drafted within the EU instead. So it's just a matter of actually more or less trying to come to an agreement on how this kind of convention should and could be formulated. And then it's up to the states to ratify the convention if they want to. And it's very obvious when you look at the convention that it's much more principle-based and very much less detailed than the EU's AI Act. So the starting point is completely different. And the drafters have an explicit intention to remain consistent with already defined the existing definitions already used in other instruments. So it's going to be less strenuous to also use this convention once you have already other legal instruments in use, for example, within the OECD or the EU. And one of those definitions, which all the drafters have a big problem with, is, of course, the definition of AI in itself. So I put on the slide here the definition of AI put in the draft for a convention at this point, which is, of course, a very broad definition, as it tends to be in all the legal instruments. But just to give a short introduction to also how the draft, what it looks like at this state, and it's still very much being drafted, and it's very much open for discussion at this point still. And of course, it's not finalized in any way whatsoever. But after the initial preambles, we do have a chapter 2, which has the fundamental principles, or you could say that this is sort of the bulk of how the draft is going to look like. It's application of artificial intelligence system by public authorities, which I thought was very interesting in this setting in particular. And you can see that the obligations that are relating to public authorities is very much that they shall ensure that anything that they do will be in line with the continuous protection of fundamental human rights. So we can have in Article 5 an example of obligations relating to public authorities, and we have in Article 6 requirements regarding respect for human rights, that each party shall take such measures as are aimed at minimizing and, to the extent possible, preventing any unlawful harm or damage to human rights and fundamental freedoms, which could result from the appropriate application of artificial intelligence systems by public authorities. We can see in Article 7 that we have requirements regarding respect for democratic institutions and the rule of law. So it's really putting the foot down in saying that all these fundamental human rights that we already have in place must still be protected. And we can see just a few examples more in Chapter 3. We have the application of artificial intelligence systems in provisions of goods, facilities, and services, which is also very much the transference of not just public authorities doing things, but we also have, of course, private parties using artificial intelligence, just as Julia just mentioned in her previous talk here, how, of course, we cannot just say that they are not obliged to protect fundamental human rights, of course, as well. So we can see here that they must also ensure that it's fully compatible with domestic law and any applicable international law, insofar as these require relevant public and private actors to respect human rights and fundamental freedoms, and so on. We also can see in chapter 3 that the draft is very much in pointing to the need for insurance of protection of different principles: principle of equality and anti-discrimination, principle of privacy, data protection, principle of safety, but also, of course, principle of safe innovation. It's very much a balancing of still protecting human rights, but also, of course, making it possible for safe innovation, so that those very much engaged in promoting new systems with the use of artificial intelligence systems will be able to do so as well, as long as they ensure protection of human rights. So I just wanted to sort of highlight the difference between the CAI Convention and the proposal for an AI Act within the European Union, that this CAI Convention has a much greater focus, which of course is obvious depending on the source of the convention, being the European Council, of the protection of human rights. It's not very particular when it comes to describing different aspects of risk, for instance. It's not that kind of meticulous in describing different uses of artificial intelligence and grading them in different risk categories and so on, but it's much more principle-based, that anything you do when it comes to AI must also be in line with the protection of fundamental human rights. So I think that these two instruments and other legal instruments as well, I haven't been able to follow your discussion in the morning, but I'm sure that you have also mentioned, of course, the other types of regulations on the EU level, as the DSA and the DMA directives and so on as well. All these can probably be a very much difficult journey to sort of get a big overview of, and make sure that all the parties engaged in algorithmic use have full competence and knowledge of. But I think the different systems will complement each other in necessary ways as well, in order to make sure that when it particularly comes to the protection of fundamental human rights, isn't left any gaps and holes when it comes to the protection of fundamental rights and the rule of law. Thank you very much for your attention.
Thank you, dear Sandra. Yeah, that's a great piece of convention. And yeah, we had this morning discussion, and I also said that I agree with Pьотr that European Commission approach is better than some other approach, and it's reasonable to regulate high-risk AI. But at the same time, I think what we see as high-risk AI, all AIs is a high-risk AI, yeah? So we have some time for questions, if any, but if not, I have one. Okay, let me start with my question, but maybe after this, someone else want to ask. My question is, do you think it is a race? It's a kind of race to define AI, to regulate AI draft, Commission, Parliament, and Council approaches to directive from European Commission, and now also Committee on Artificial Intelligence from the side of the Committee of Ministers to elaborate this convention, to deal with this convention, elaborate a new base. What do you think about this?
Sorry, did you mean about the?
It looks like a race. Who is the first one?
Right.
Who
No,
define
sorry.
AI and pose some obligations, and then other will need to embed it in this system there.
Right. Yes, exactly. I get it. It's interesting when you look at the CAI Convention and the statements from the European Council. It's very much that they want it to be something as that's at least what they're saying, that just should complement. So it's not a question of sort of taking the lead sweater in order to define AI, for instance. They have actually made use of the already existing definitions of AI, so they don't want to have another definition, for instance. So they don't want to come first to to the goalpost in order to define AI, for instance, and so on. But it seems like, at least what we can read from their discussions in the field, that it should just be a complement to other regulations, instead of sort of taking the lead sweater in defining things and making it a more narrow approach possible for other actors in the field. And it's also said that this convention must be complemented by soft law instruments, other guiding principles, that different actors also must take their own responsibility in providing directions for the use of AI within their particular type of field, and so on as well. I think it's just difficult, though, to see how this type of convention will be enforced in the future. How will the individuals be? How will they be able to actually go to the European Court of Justice and in Strasbourg and say, my fundamental human rights have been infringed by the use of AI in this setting, for instance? So I think a big question for me when it comes to liability questions and being responsible for AI and so on is the difficulty in all these type of drafts that are being made now that can be described as a race. But my questions along the line of this is, how is this actually going to be functional? Will it just be sort of a paper product, or a huge ton of paper products that just will tell us about rights, but it will not be practically enforceable for individuals, for instance? How will we ensure that this actually also become practical law, so to say? And that, I think, is going to be really difficult, since we have had a long history of the development of human rights when it comes to the European Convention of Human Rights, which is still being, it's huge difficulties in actually making individuals getting their opportunity to be heard before the court at all, from a practical point of view. So the enforcement possibilities, I'm really interested in seeing how is this going to be possible at all.
Yeah, thank you. That's always a question to have a working mechanism. That one of the feature of European Convention of Human Rights, when we discussed it with students, it's the fact that Convention and European Court of Human Rights is a pieces of mechanism at European Court of Human Rights makes it possible to work properly. Okay, thank you, dear Sandra. Do we have one more short question? Okay, then we will have some possibility for questions after the next presentation. And I'm happy to introduce our next speaker, Zuzani Bazelll. I need to say that I promise that next time when we plan our events, we will take into account this time difference also in United States, because it's around 6 morning, maybe in US now. But anyway, Zuzani Bazelll is an associate dean for business at Southern New Hampshire University. Her current research interests are digital ethics, fintech, cryptocurrency, the future state of financial industry, and the mortgage markets. And she will present the interesting topic, the AI in the sky, AI-powered drones, impact on the insurance industry. Dear Zuzani, it's your time to present.
Here's the unmute button. Oh, good afternoon, everyone. Or yeah, good afternoon for you, everyone. Thank you for having me. I appreciate this opportunity. It's nice to see everyone. And this presentation might be a little bit different because my background is more in finance than law. So you will see some numbers, and I apologize. It's very US centric. It's not European centric, but it's going to help you because, as you know, US is very litigious society. They sue for everything. And if you ever saw a US movie, there's ambulance chaser for a reason. They pretty much have lawyer on every corner here. It's the eye in the sky is the insurance companies started using AI-powered drones to estimate impacts on after big disasters. And I don't know why it's not working today. Ooh. So insurance is the only product that both the seller and the buyer hope they will actually never use. So if we look at the year 2023 in review, we have seen wildfires that people in Europe lost $4.4 billion. And so far we have no insurance estimates. The recent Hawaii storm cost $6 billion. And again, there's no insurance estimate. The May floods in Europe cost $10 billion and only $1.1 billion out of that was insured. And the earthquake in Turkey and Syria, we lost 40 billion and only 5 billion was insured. And Morocco was 10.7 billion and cost 8% of the country's GDP. And I didn't dare to put the human loss. And this is because of the urban sprawl and pretty much because of climate change. This is all reflected in the insurance costs. So the damage is very large, and the customers and insurance companies need to work fast and they need accurate data, and insurance payouts could be insignificant. Well, don't feel bad for the insurance companies because they make a lot of money. If we look at Munich, Germany Alliance, they made $7.81 billion in profits in 2022. Paris AXA made 8.39 billion, and AIG in New York made 9.39 billion in 2029. In order to keep up those profits, they tend to increase premiums. And why is that? Because the main goal of a publicly listed company, which all of these are, is to increase shareholder wealth. And that's where our drones comes in. So why did they start using AI drones? Because AI drones are much faster to make decisions and capture data and analyze it. They can fly autonomously over larger areas, scan the distances, and actually access dangerous areas that were destroyed. So if we look at it, they can perform high accuracy computation on the spot and bring it back in and give accurate estimate what's going to happen to the area. In 2021, the UAV market was about $127 billion. It's used in infrastructure, agriculture. Insurance right now is only about 5% out of that. There's some good about it. When we look at claims processing, the accidents, or when an accident or natural disaster occurs, the insurers can deploy drones and assess the damage much faster, and it expedites the processing and provides the policyholders with faster payouts. However, the drones are unable to assess the damage inside, so it still leads to additional litigations or additional processing time, and people are still waiting on actual person to come in and estimate what happened to their home inside. What is also happening now is fraud detection. So the insurance companies realize they can do large scanning and do fraud detection where they can see, AI can use an algorithm to analyze data to detect fraudulent claims. For example, if you have damaged roof already and then you claim it was damaged through hurricane, well, we have a scan from a year ago, it was already damaged, leaking, or a month ago, we keep data, you're not getting paid for the roof. It reduces the operational cost because drones can significantly reduce the operational costs by automating every task that would otherwise be done by human inspectors or adjusters, like going to certain areas. And it's more environmentally friendly because you are using the AI-powered drones, so you don't have to drive to certain places. So there is a lower carbon footprint. Then there's the drone usage, AI drone usage that could be, I call it the improved. The risk mitigation. Insurers started using drone data to proactively advise policyholders on risk mitigation strategies, and then enhance risk assessment, where they use the drones to survey large scale areas, and this is creating problems. Both strategies send the drones out proactively, and they scan large areas, and based on that, they either drop policies, decrease the home policy values, or increase premiums. So and then they just say, we have these scans, and this is what we analyze based on the data and based on the area you live in, and we determine these payouts. So when we look at, I think everyone saw this image, when we look at the AI drone scanning, Florida, any homeowner with solar panels was either told that they will drop the policy premiums or they will be adjusted. California did a large scanning, and if you show debris in yards or shrubs too close to the homes in fire-prone areas, again, you were either asked to clear debris, shrubs, or the policies would be revoked. Arizona, there were examples where if homeowners haven't used the pools and drained them, that created scenario of neglect and their home values were decreased. And if you remember this home where everything else burned, they started using it as example because they actually used this metal roof and cleared the shrubbery around it and put stone near the base. So this is now used as a fireproof. And when they did a wide scanner of AI before and after, it was the only home that did that. So this led to a new insurance premiums adjustments, and they went up in certain areas by 41% and in Florida by 57%. So there's not much residents here can do because insurance premiums are non-negotiable in the United States. You can either bundle them or you can go with a different provider, or you can cave to their demands and make the adjustment on your home. So what are the laws governing the unmanned aerial vehicles in US? All the laws are mandated by FAA, the Federal Aviation Administration. It's Part 107 FAA, the drone regulation for commercial use. And it was enacted in 2016. And then when AI drones came in play and commercial drones were more in use, it was changed and updated in 2020 by the Code of Federal Regulations. And the most important are that all drones must be registered. They are not allowed to fly faster than 100 miles per hour or 160 kilometers. They cannot fly higher than 400 feet, which is 122 meters. They cannot weigh more than 55 pounds. And you can fly at night only with permission, and you are respecting privacy. And this is where the rub comes in. There is no privacy law. It is only respect. So because FAA controls the sky in the US, you as a homeowner own the land and the house, but you don't own the sky. The FAA controls the sky. So under the current law, it is considered a public street. So the homeowners have no right to keep anyone out of a public street. So they have no right to keep anyone above the sky. So if somebody flies a drone above you, really there is nothing you can do about it because you don't own the sky and control it. FAA does. The FAA also does not regulate how the UAV gathers data on people or property. The FAA only regulates on voluntary best practices and recommends to check local laws, because every single town and every single municipality can make their own laws on what to do and how to treat drones on your property. So one of the most common questions we get in Google searches around municipalities is, can I shoot down a drone when it flies over my property? And the answer is no, because it actually is registered as an aircraft because it's controlled by FAA. So it's the same as shooting down Boeing 747, even though it's a small private drone or commercial insurance drone. You can't do that. It's punishable by law, and it's against federal law. The same way you are not allowed to blind it with a laser. So that is, you have no, pretty much you are stuck unless you know who is controlling the drone. You need to talk to the person in person. So what are the risks to insurance companies using AI drones? There are some privacy regulations of trespassing. If you fly below the navigable, so if you are way too low, so you are encroaching, if it kind of like flies above my head and it hits me, that's aero property rights, then you are kind of on my privacy regulation. That's my right around me. Or if you are trespassing where the drone crashes into your property and you are going to physically retrieve it, that is illegal. You need to ask the homeowner for permission. So that is trespassing if you don't ask. Theoretically, insurers have to ask every single person for pre-approval if they are flying a drone over their house, but they are not doing it because they are just saying that they are flying it over a large, vast area. So they are not scanning for a separate house. So if they're not scanning for a separate house, they don't have to do that, separate property. So if they're scanning a large area, they don't have to notify them, only if they're scanning one house. Casualty and liability, if they do a bodily harm to a person in a path of the drone. Hacking and data loss, because AI drones carry sensitive data, they are susceptible to a lot of hijacking via spoofing or cyber attacks via spoofing. And you talked about liability. There is actually AI drone insurance already. It is a huge market, so the insurance companies created a new revenue streams for them, because why not? It's more money. Commercial drones need to be insured to cover any costs associated with accidental damage caused by operations of the drone. So it's an innovative product under technical liability and general liability. And I think this is maybe where AI liability might come in under the general liability. So it's theft coverage, loss of flyaway, payload, ground equipment, and personal injury. And the market is right now 1.31 billion, and it's predicted to grow to 1.81 billion at the compound annual rate of 8.4%. So there is already AI drone insurance, so there might be additional AI insurance coming soon because all the major players in the insurance industry started offering it, even in Europe. Any questions? I'll stop sharing.
Thank you, dear Zuzana. Super interesting. And I need to say that to have a non-European perspective is highly beneficial because sometimes we're so focusing on details or sometimes we're not knowing so much about other legal systems, we have this possibility from Ukrainian point of view to be quite outside, but we tend to belong to European legal systems anyway. Yeah, I maybe I need to ask, does anyone have questions now?
May I ask something?
Of course.
Sure. Go ahead.
Thanks. Well, for our last speaker, because I ended my intervention before talking about insurance, so just because it's the recent thing, I would like to know how this market came out. I mean, did they perform some studies saying, okay, we can supply insurance at a good premium, or it's like, for now, we are not sure, but we want to be the first players on the market. So even if we lose money in the beginning, in the long run, we're going to be kind of the reference for this insurance market for drones. There are some studies, or it was just okay in the current situation, so there was a proper market for it.
So because it's registered as an aircraft, you have to have insurance on it.
Mm-hmm.
It's kind of like a car. It depends on the state. In some states, you only have liability, and in some states, you have to have a full coverage. For example, New Hampshire, where I live, you are required only to have a liability insurance on your car. In other states like North Carolina or Maine or Massachusetts, you have to have a full coverage. So vehicles, because it's registered under the FAA as an aircraft, you have to have a coverage for it. So that's the difference. I think they had to start offering it because of the personal bodily harm. I think that was the main thing. I think that's why they started offering it. And it wasn't out of, they will never lose money on it. I mean, I haven't seen one insurance company lose money. I know when it comes to these AI drones, that you register, because they have registrations with the FAA, they are fully registered like you would register a car. Then with the registration, you have to put proof of insurance with them. Not for a personal drone. I'm not talking about the small drones you buy for your kids that you stand there and you charge them at home and you fly them in the yard. My neighbor has one, and we have policies for that. And in our town, we have policies for drones too now. And you're not supposed to fly them to your neighbors. But
thanks a lot.
You're welcome.
Thank you. We have one more question from Sandra, please.
Well, thank you, Susanna, for a very interesting presentation. I was just wondering, does the insurance cover also loss of data if someone sort of, as you say, hijack the drone, or it crashes into someone's yard and that person takes the opportunity to sort of take the drone with all the data as well? Or how does the insurance protection cover those kind of losses?
It's mostly just the shell, not the loss of data. That would come under, there is a different insurance for the cyber, that's under the cyber. There's a separate insurances are for the cyber portions. That's the IT insurances. They separate the insurances by hardware and software.
Okay, thank you very much.
You're welcome.
So different from other pictures, I need to say, and I even, now the war against Russian Federation turned into drone war, and we mostly perceive AI drones as something very positive, if it's not Russian drones, of course, but that's something which could help us and could help save the lives of people from Ukrainian army. But when I'm hearing your presentation, I started to think that it's really in just in different contexts to use AI drones. But I have a short question maybe. What do you think how it should be perceived, regulated if we use drones in some ordinary situation, or if we use them in the situation of emergency, like earthquake or something, and if we use them in the situation of war?
I think there are positives and negatives, right, to every situation. I think drones, especially the large commercial drones, have a really good positive usage, and we have seen it because even though they have a small payload, you can still deliver medicine to far corners if you program it right. You can deliver medicine, and actually UK had the program where they could deliver medicine into far corners. And in Africa, drones, commercial drones, are used to monitor wildlife and stop poachers and stop poaching. So that's used, AI drones are used in Africa for that specifically, which is really positive. And in terms of war, you know, you see it in on your side. There is also positive from your side. So, and negative. Unfortunately, in war, we see both.
Yeah.
But in peace use, there's people who want to benefit from, I'm going to drain other people when I see they are doing something bad. But I think delivering medicine, and monitoring the wildlife, and assessing quickly, there's a risk the fire is spreading. When they use the commercial drones for fire control, they could see where the fire is moving, and they don't have to do it manually anymore, where they have to send a person in and put them in danger.
Thanks a lot. We have one more question from Patricia. Can you hear us?
Patricia, can you hear us?
Yes. Can you see me now?
No. But
Oh,
Yeah, now we can.
So thank you so much for all those very, very interesting presentation. I have some question to Sandra. I don't know if perhaps I missed the beginning of your presentation, so perhaps you already answered the questions, but the relationship between the regulation and the convention that you described, I have some question about that, and also about the competence of the European Court of Human Rights, because the first question could be if it was a reflection to have, instead of a convention, to have a protocol, additional protocol, in order to have the competence of the European Court of Human Rights in a like automatic manner. Because if it's a convention that it's, how is it possible then to have this convention in the field of the competence of the European Court of Human Rights? It was a question. And then I had also the question about the parties of the convention. It will be open to other countries outside the Council of Europe? Could it be open to the European Union? It will be a party, and then we'll perhaps, as for example, the Aarhus Convention, that you have a convention that the states are party to the convention, but they have also to implement in a way the Aarhus Convention through directives, because the European Union is a member states, is a party of the Aarhus Convention. So I have many questions.
Thank you. I don't know if I can answer them all, but to begin with the last one, I haven't seen any sort of limitation as to the European Union not being allowed to also ratify the convention. It's of course difficult to see if the European Union also wants to do that, since they have a convention of their own, so to say, an act of their own. And when it comes to the protection of fundamental human rights and freedoms, it's already in place in that sense that the European Convention on Human Rights is also something that the European Union has in their own treaty that they must oblige to, so on. So it's difficult to say at this point if they will find it necessary to also be part of this convention, or if they will say that, well, we already have protection of human rights, it doesn't need to be also enforced in this sense. So that I haven't seen any discussion on it so far, but it's definitely open for them to ratify it if they want to. I haven't seen that the Council of Europe will hinder them from doing so. When it comes to the choice between a convention and a protocol, I haven't seen anything actually why they chose this path actually. So I can't answer that question. Sorry about that. I will definitely look into it more, and perhaps it's someone else in this group that can give you better information than I can on that point. So sorry not being able to answer that question. Was it some other question as well?
No, I think you answer all my questions. Thank you.
Okay. Thank you.
Thank you all again.
Yes, thank you so much.
Thank you very much. See you tomorrow.
See you.
Goodbye.
Thank you.
Thank you all.